I'm Patrick Coyne. I'm a neutral at JAMS. I do mediations, arbitrations, and neutral evaluations. A lot of mediators say they're facilitative and then they tend to get more evaluative as the day goes on. I think it's more, instead of being evaluative per se, I think it's more talking through with the parties and making sure that they have really thought about the risks they're facing. The evidence from the other side is X. How does that inform your thinking about the case? Have you thought about your damages claim? And that's really the key when you're mediating, is you want to try to look at both sides evenly, figure out what each side's risk factors are, and try to come to a reasonable position that satisfies both parties' needs and interests in the case. What makes a good arbitrator is someone who can really dig into the record, thoughtfully review all of the evidence that's presented in a judicial sort of sense, and you need to provide a framework in the arbitral award that answers those issues each party has raised. Critically important to manage the case efficiently. You have to move the process along on a predictable, steady, determined basis to reach a resolution. And that means not entertaining a lot of things that parties tend to do in district court to try to slow down the case or throw roadblocks on the other side. My career has been mostly focused on complex cases. I've done a lot of simple cases too, but most of them have been bigger cases, large patent infringement cases, antitrust, unfair competition, defamation. Trade secret in particular are fascinating. Every case has emotions, let's not kid ourselves. No matter what the case is, there's always a human component to it, and people are wrapped up in how that gets resolved. And I think it's helping the parties through that. You have to develop a rapport with people, and it's an essential element to address in a mediation or an arbitration in resolving that dispute effectively.